Okay, Tim, now we're recording and people should start coming in at the bottom. We should see them coming in. And if you move your mouse, you ought to see Q&A and chat both at the bottom of the page.
I don't see that. I wonder if it's because I'm oh, there we go. Q&A, it's up top. Okay,
Oh,
great.
yeah, different
now.
Yeah, different computers put it different places.
And I do see 8 participants.
And generally people will still be coming in after we start. That's
okay,
just the way it generally goes. For all you attendees out there, we're waiting for a few minutes to get people to sign in, and then we will start the presentation. Not nearly all of the people are signed in, but I'm going to go ahead and start us because I hate to make people who are on time wait for people who are running a little bit behind. My name's Jackie McLean, and I am co-chair of the Capital Corridor chapter of SCORE, serving 21 counties in Northern California. Today, we're very lucky to have Tim Del Castillo from Castle Law with us. He's going to be addressing issues about the determination of whether a person who's employed is an employee or an independent contractor. This is a question we get all the time. I need to let you know that the session is going to be recorded and you will receive a copy of the recording and the slides. If you have questions, go ahead and type them either into the chat or the Q&A, and Tim will try and answer them at the end of the presentation. At this time, I'm going to turn it over to you, Tim, and we appreciate your being with us.
Great. Thanks, Jackie. I'm happy to present to you on this topic. It is something we get questions about a lot as well, and it's not without good reason. The laws you'll see is still a little bit complicated, and especially newer businesses, trying to get things right. This can be a difficult question. So a little bit about myself. I am an attorney and managing partner at my law firm, Castle Law, in Roseville, California. We do employment litigation only. All we do is employment law. And typically we're in court fighting cases. We represent both businesses and individuals, so we see things from both sides. So the first question is, what is the difference? What are the main differences between a W-2 employee and a independent contractor? And I think that a lot of, especially businesses that are starting up, when they understand these differences, it becomes very tempting to have workers classified as independent contractors instead of employees. And it will become evident as we talk through these. So when you have an employee working for you, that employee must be paid at least minimum wage for all hours worked. Of course, if it's a salary employee, what we call an exempt employee, if they're performing exempt duties and they're being paid enough on a salary basis, you don't pay them by the hour. So there are exceptions to that. There's also some commissioned employees that are exempt from being paid at least minimum wage for all hours work. For example, outside sales employees can be paid on a different basis, essentially a commission only basis, but you have to meet certain tests to qualify for either salary or outside sales, and we don't have time to get into all those. If you're a business that has an employee, you have to pay payroll taxes. The employee has to pay taxes, Medicare, and the employer has its share of payroll taxes. You have to make sure you have workers' compensation coverage for all your employees. Even if you have only one employee, that is the legal requirement that you have workers' compensation coverage. There's a cost associated with that, of course. And you have to make sure that you are complying with all of California's wage and hour laws. Those are the laws that are typically contained in the California Labor Code and also in the wage orders. And we'll talk a little bit about some of those, but there's really too many to cover everything in this particular webinar. Suffice it to say, it's complicated and it's difficult even for our business clients, some of whom are very large and have thousands of employees, to get everything right. Large part of the reason for that is because the laws are constantly changing and it's like a moving target with a lot of wage and hour areas. And then lastly, if you have an employee, you have to be aware of equal employment opportunity laws. So on the state level, that's the Fair Employment and Housing Act. On the federal level, it's Title VII. Now, those laws will not apply to every single employer. It depends on how many employees you have. But once you reach, as little as 5 under state laws, you have to be cognizant of equal pay issues, gender issues, race issues, all the way down the line, the protected characteristic laws that apply to employees. So what about contractors? What do you have to think about, or how are they different from employees? Well, you don't withhold taxes. You simply report what you paid them on a 1099 at the end of the year. And largely for that reason, independent contractors can be cheaper for your business. And a lot of the selling point for people to work as independent contractors is it can be more flexible. So it can be more flexible for your business as well. So a couple caveats to both of those issues. Obviously, you can pay an independent contractor more than you would pay an employee. So it's not necessarily cheaper. And a lot of times, more sophisticated contractors, knowing that they have to pay the tax burden all on their own, will expect a higher pay than a employee. And then in terms of flexibility, with California is a default at-will employment law state, which means the employee or the employer can terminate the employment relationship for any reason at any time, as long as it's not an illegal reason. So I don't personally give too much weight to the idea that it's more flexible, but that is something that people like about independent contractor relationships. Now, I want to point these differences out because this is, as I said, a lot, especially new or growing businesses, are very tempted to say, hey, that's great, it's cheaper, let's make our workers independent contractors. The problem with that is that you really have to make sure that you meet the test to do that, because there is no such thing as misclassifying an employee as an employee. But there certainly is lots of lawsuits, some of which my firm has been involved in, dealing with calling somebody who should be an employee an independent contractor. So what if you get it wrong? What if this person should be an employee, but you classify them as an independent contractor and get it wrong? There are numerous violations, and this illustration is the plaintiff's lawyers and the IRS. They're going to come after you to take your money if you get this wrong. So things that employees get that independent contractors don't, which means things that you could get sued for if you misclassify a worker as an independent contractor, are meal break violations. They'll say, you didn't have any policy for providing contractors with meal breaks, therefore there's a penalty for that. Rest break violations. There's also in the labor code specific monetary penalties for intentional misclassification of a worker as an independent contractor. And a common claim in these cases is minimum wage claim, which means, typically contractors, you don't pay by the hour, you pay them by the job. And so if you're doing that with somebody who should be an employee, they're going to say, hey, I had a lot of time that I worked that I never got paid for. That's a minimum wage claim. And with minimum wage claims, there's something called liquidated damages, which means you not only owe the minimum wage, but you also owe they double it as a penalty. And then there's things that I didn't list here on the chart, which in employment litigation, we call derivative penalties. And those are the things that'll really hit you. So whenever you have a failure to pay wages, you have necessarily a wage statement violation. You have a waiting time penalty violation. What that means is if the person is a former employee and you didn't pay them all their wages, you have a potential of up to 30 days worth of wages for every day that the final pay is late. And so a lot of times in cases, we see that amount being much more significant than the underlying underpaid wage. And then besides just private litigation, you have, as I mentioned, IRS and state tax liability. The IRS does do audits of workers and classification. If they find that you have misclassified a worker as an independent contractor, they will come after you for unpaid payroll taxes and other penalties. And that's on the federal and state level. Other claims that the employees themselves can bring are unreimbursed business expenses. So typically contractors provide, and they should provide, all their own tools and expenses. You don't reimburse contractors for mileage, for cell phone use, for their tools and instrumentalities of work. But for employees, you are required to provide all of that. And so that's a claim that a worker may have. Also, workers' compensation. You can get in trouble with the Workers' Compensation Appeals Board if somebody should have been classified as an employee and you did not provide workers' compensation insurance. And I mentioned waiting time penalties already. And then lastly, the real big scary thing on here, which I guess should have been read, but depending on the size of your organization, if you have, more than a handful of employees, you have a risk of, or contractors rather, you have a risk of a lawsuit being a class action, or PAGA refers to Private Attorney General Act. And that is a California specific statute that applies penalties for violations of the labor code. Okay, so hopefully I scared everybody sufficiently to be motivated to understand why this question matters. So I want to take a little bit of a journey through history to understand this issue, and it will become clear why, because the test today refers back to prior tests with some exceptions. So it's important for us to understand how California law has developed on this issue of when is a worker an independent contractor? That's the question. And so this is a case from the California Supreme Court, Tyberg, 1970, in the legal profession that truly is ancient history, because case law develops so rapidly that unless you want to show that a rule has been established for a really long time and has a lot of value behind it, you would never cite a case from 1970 in a legal proceeding. But what this case said is the principal test of an employment relationship is whether the person to whom service is rendered, that's you, the business, has the right to control the manner and means of accomplishing the result desired. So pretty straightforward, pretty simple. The operative word here, and you're going to see this throughout all the tests, is control. And that's been a familiar pattern until we really get to the ABC test of something that courts generally looked at, different factors, but how much was the hiring entity, the business, controlling the manner and means of accomplishing the result desired? So this was often described as, you can control the result when you hire a contractor, but you don't tell him or her how to do the job. You say, this is what I want to be accomplished, and this is what I will pay you. I'm not paying you by the hour. I'm not telling you how to do your job. You're the professional. You have the particular skill. I want you to perform that result, produce that result for me. So then we get into the what I call early modern history of the development of this case law and independent contractor test. And this is a California Supreme Court case from 1989. And this is where, for whatever reason, the California Supreme Court to make the test more complicated. And it was really kind of complicated because they gave a lot of different things that you need to look at. And so we refer to this as the Borello test. And what some of the things that the Borello case said, building on that older case law, is they used the Pryor test and said the most important thing, the principal test, is the right to control the manner and means of accomplishing the result desired. Okay, so kind of consistent, but then they added, well, also strong evidence in support of it being an employee-employer relationship is if you can discharge at will without cause. That might seem a little counterintuitive because you would think that, hey, I can tell my contractor I don't want him or her to work for me anymore, but it's a little bit different. When you have a true contract, you say this, again, this is the result I want. This is what I'm going to pay you. If they don't perform the result, you have a breach of contract. You can't just say, oh no, you're fired, because then they could sue you for breach of contract. It's really contracting relationship. But then the Borello court added these other considerations that courts have struggled with looking at. Is the person performing the work involved in a distinct occupation or business? So you want to, ideally it's another business that you're contracting with, not just an individual. Is it something really unique, something you don't do? And then the next question is the worker a specialist who works without supervision? Think of, a lot of times when I deal with independent contractor cases, I want the contractor to look something like the people that I may perform to do work on my house. Okay, a carpenter, a painter, a plumber. I'm not going to get under the sink with the plumber and tell him, hey, why are you using that wrench? You should use a different one. They're the specialist, not me. The next question is a particularized special skill required? Something that, the plumber has a lot of experience, some education, probably apprenticeships, and a lot of these trades. They have skills that I don't have, that the normal business owner does not have. And as I mentioned before, when you have a contractor, the question is, are they providing instrumentalities, tools, and the place of work for the person doing the work? If you hire an artist to create a painting for you, which would be an appropriate contractor relationship, unless you happen to be an art studio. But typically, they're not coming to your office to do the painting. They're doing it in their own studio, their own whatever, and they're providing all their own paints, brushes, etc. And then length of time. So typically what courts would look at is when there's a relationship of a long duration, that's indicative of an employment relationship, not an independent contractor relationship. Independent contractors, again, they're hired for the job. And that doesn't mean you can't hire an independent contractor to perform another job if you were really happy with their result. But when you see ongoing for years relationship, that's more indicative of an employment relationship under this Borello test. And then is the person paid by time or by the job? If they're paid by time, they should be an employee under the Borello test. Is the work a part of the regular business? And this is really going to become key when we start talking about the ABC test, which is the current law for most situations. Is the person doing what your business is in the business of doing? If the answer to that is yes, now under the ABC test, they cannot be a contractor. Okay, but under Borello, that was just one factor. So it was possible you could still have a contractor, even if the person was doing the same thing that your business is doing. And then finally, the understanding of the parties. And we used to always advise employers before the ABC test, you want to have all your contractor relationships actually in a written contract. So you have something to point to that everybody understood that this was the relationship. Okay, and then fast forward to modern history. So this is in really the last, I guess it's been 5 years now already that this case has come out. Everybody, on the street that has some familiarity with employment law in California has probably heard of ABC, but not everybody, unless you're a lawyer, may have heard about this Dynamics case. So Dynamics was really what got the ball rolling in this whole independent contractor revolution, if you want to call it that, in California. Dynamics was, again, another California Supreme Court case, and courts had a hard time dealing with Borrello. And the California Supreme Court in Dynamics is a really long opinion. It's like 40 some pages, and went through the whole history, looked at other states, and it was Dynamics that adopted the ABC test. And they said, hey, these other states use this test. We're going to use it in California now too. We're going to change the law, even though they're not saying they're changing the law. That's what everybody understood it to be, and that's what it was. So the ABC test, and we'll go into each of the factors, but briefly, under the ABC test, which is supposed to be more simple, it's really 3 things, all of which need to be satisfied in order for a worker to be properly classified as an independent contractor. The worker has to be free from control of direction of the hiring entity in connection with the performance of the work, both under the agreement, under the contract, and in fact. And so the distinction there is important. We'll talk about that, but both have to say, hey, I don't control how you're doing the work. The B is where there's a lot of these cases that we see in litigation now, and that is the requirement that the worker not perform work that is within the usual course of the hiring entity's business. So that's something where it gets a little tricky, and we could talk about some edge cases on that. And then the third requirement, C, is that the workers engage in an independently established trade, occupation, or business, doing the kind of work that's performing for you. And more on modern history. About 2 years after Dynamics came out, the legislature in California said, hey, we like that. And technically, Dynamics only applied to California wage orders, not the entire labor code. But the California legislature said, we really like what the California Supreme Court did in that case. We want to codify it. We want to put it in the labor code itself, and we want this to apply to the whole labor code. We don't want there to be any ambiguity about, hey, it's only the wage orders, not the labor code. And we're also going to apply it to the unemployment insurance code. And we're going to apply it across almost all industries. Now, the interesting thing too, when AB 5 was passed, is that there were a lot of lobbying efforts going on at the time, and there were businesses and industry groups that were not happy with Dynamics. And so groups that were trying to work with lawmakers to get exceptions to their particular industry built into the law, which is a lovely part about how the sausage is made in our state with different interest groups. So there are built in to, even though Dynamics, the ABC test was supposed to be streamlining things, making it more simple, I think it actually got a little bit more complicated, because now you have all these exceptions that you need to be aware of where you might have an easier test. And those exceptions include if it's a bona fide business to business contracting relationship. Now you got to be careful with that one, because it does have requirements. I've talked to a lot of people that say, oh, well, hey, I required this worker who was doing the work within my business to have their own business license, and they went and got their own workers' comp insurance, and et cetera, et cetera. You got to look at the statute itself. This webinar is not legal advice. So look at the statutes, talk to somebody you trust, an HR professional, one of the SCORE business coaches. Ultimately, you might want to talk to an employment law attorney, depending on what kind of relationship you're entering into here. And then referral agencies have an exception. That one makes a little bit more sense to me, and it's a little bit more straightforward, but look at that labor code if you have any questions or relationships like that. There's also an exception for professional services contracts. And this is an interesting exception because, and the reason why I wanted to talk through the whole history of how this developed is the exception is, okay, if you meet these requirements, and we're going to go more into details on these, it doesn't mean that, hey, they can be an independent contractor. It means, okay, well, then you go back and look at Borrello, and then you got to meet the Borrello test. So it's actually just added to the complication if you have either a professional service contract or one of the specific occupations. We'll get into those as well. And then Labor Code Section 2779, single event or single engagement events, one-time things. Think of wedding planners, that type of thing. But again, look at the labor codes on all of these. The music industry, there's some exceptions. Construction, subcontracting, there's some exceptions. A data aggregator, whatever that is, if you have one, then you'll want to be familiar with that labor code. And then again, specific occupations, and so some of these you start to see the lobbying of the groups that went into AB5. Okay, so there's even more modern history after AB5 was adopted in Prop 22. If you remember back in 2020, we had all these ads during election season bombarding us on TV with how the drivers for Uber and Lyft really loved being independent contractors because it provided them with so much flexibility. They really didn't want to be employees. Of course, those were all paid for by Lyft and Uber. They spent millions and millions of dollars. I think I might be right that it was the most money ever spent on a proposition in California. So somebody could correct me if I'm wrong about that. But that did pass. And so the voters approved that, hey, we're going to give another exception to AB5 to ride sharing. I think it might have applied to like DoorDash and those kinds of gig economy stuff. And, part of this makes sense. We have a evolving economy. And so there is an element, especially with those jobs, to flexibility. So I'm not making a judgment one way or another about good or bad, but that's what Prop 22 is. And then even more recently, a couple of years ago, I believe it was just a trial court that ruled that Prop 22 was unconstitutional because the voters did not have the power to usurp legislative rulemaking. And that is still up on appeal. And so we don't have a final rule on whether Prop 22 will stand or fall. So let's get into the details of the ABC test. So again, A in the ABC test is the worker is free from control and direction of the hiring entity in connection with the performance of work, both under the contract for performance of work and in fact. So I put Ayala here because that's the name of a case that predated Dynamics and AB5 and everything, that the workers, in fact, were free from direction and control, but the contract said you can control them. And there's other cases the other way around. The contract says we can't control you, but in fact, they were controlled. So you got to make sure, as with many areas of California employment law, it's not just a good policy, it's not just a good contract, it's the reality on the ground. And I believe this Ayala case, and there were some others around the same time that were like newspaper delivery type services, some type of delivery service. And so you want to make sure, if you have a contracting relationship, that the contract itself says that you don't have the right to control how they do the job, and that in fact you don't control them, even though the contract says you're not supposed to. And then B, and again, this is where most independent contractors, they were okay, kind of fell apart. And this is that the worker must perform work that is outside the usual course of the hiring entity's business. So this language, as you can see, is pretty vague. It's open to different interpretations. Does that mean that they can't do anything that any of my employees do? That's pretty broad. Or does it mean that They just have to have something slightly different than what I do. I design widgets with 2 knobs and they design widgets with 3 knobs. That's probably not going to be enough. Okay, so there's extremes on both cases. The bottom line is they should not be performing work that your business already does. There have been some cases recently, which frankly, I think are kind of ridiculous, where, for example, janitors. Okay, so you might have a retailer or a business that's doing something totally different. They're not in the business of running sanitation or janitorial work, but they hire a company to come in after hours and do a lot of cleanup, clean the bathrooms, that kind of thing. But let's say this company also has its own in-house staff that does that work sometimes. And then they have a contracting company that also does it. Does that mean that they fail the B part of the test for the outside company that does some of the janitorial work? So some law firms have taken that position. To me, that's kind of a, it's, I guess, a closer case, but, seems pretty ridiculous to me because a grocery store or a retail, in my mind, they're not a janitorial business. But again, it's risky. There are cases out there. And then the most extreme case I've heard of, which is really ridiculous, is a lawsuit that was filed under the theory that whenever you and I go to the Safeway or the grocery store, the drugstore, where they have a self-checkout, that makes us employees of the business. What? That's crazy, you're saying. I think it's crazy too. But if you look at the logic, okay, Safeway or whatever store has baggers. Well, I'm doing the same work that they're doing. Am I performing work in the usual course of the hiring entity's business? I mean, technically, I guess, to me, it's just ridiculous, but you could also say, hey, if I ever take something off the shelf, does that mean I'm working? But that's the extremes to which some plaintiff employment lawyers will go in looking for cases. And hopefully common sense prevails on that issue and they get a good judge. And the C part of the test is that the worker must be customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed. Again, it's a little bit difficult to understand what exactly do they mean by independently established trade. What is that? And probably easier to understand it as their occupation is the same as the work that they're performing. So for example, and this is where I like to look at the thing of what are the kind of people that you hire perhaps to do work around the house? Painters, professional or painters that you might hire to paint your house. They have a business that is painting. They're not doing something else and they just paint, hopefully not, painting on the weekends. Plumbers, same thing. It's not, if I ever show up at your house to fix your sink, please kick me out because I'm not qualified. So you're not going to find a lawyer doing plumbing on the garden, hopefully not on anyone's house but their own. Gardeners, that type of thing. So you really want to look for this is the individual's business. This is their occupation. They are a plumber. They are a painter. Okay, so let's looks like we have a question, Jackie, in the chat box, but hopefully we'll have time to circle back to that at the end. So one thing I want to circle back with is the exceptions for professional services contracts. And you'll want to look at the specific labor code on this And this is Labor Code. Let's go back and point it out to you. This is Labor Code 2778. And you'll want to look at that if you have any professional services contracts. And this actually might be a helpful part of the answer to the question we got. So specific requirements in the statute about the business location, not being your location, being licensed, and that other businesses hire this professional service contract. And they must fall into one of these specific roles. And then some of these don't provide any definition about what the qualifications of the person must be or any additional requirements, but some do. So 2778 of the Labor Code has several subdivisions or subparts. So the specific professions or jobs that the business or individuals performing under professional service contract must be either marketing, an HR administrator, a travel agent service, a graphic designer, a grant writer, a fine artist. I mentioned a painter before, a certain type of professional that's licensed by the IRS, a payment processing agent, a photographer, a digital content aggregator, a freelance writer, translator, cartoonist, a content contributor. So think of a somebody who maybe writes blog posts for your business or puts out materials and publications. Esthetician, electrologist, manicurist, barber, or cosmetologist. That's an interesting one. I actually had a case before AB5 came out when the law was still dynamics. And as I mentioned, we represent individuals and businesses. This case, I was representing individuals. And our theory was that they were misclassified as independent contractors because of dynamics. And then the whatever industry group is involved with this particular, cosmetology and hair and that kind of thing, they got involved when AB5 was passed and got an exception. So my case essentially went away, and it was good for them. And further on the list, master class teacher, an appraiser. That's another one where we had see in litigation and then go away. A professional forester, a real estate licensee. I also had a case involving most like home purchasing and selling agents are independent contractors. They're not employees of the particular business, Remax or whatever it is. So there was some litigation around that kind of went away when AB5 passed. Home inspectors and repossession agencies. Now, the important thing, it's noted up at the top, when you have one of these exceptions, is that it doesn't mean that they're automatically an independent contractor. What it means is that you need to go back and look at Borrello. You need to look at that more complicated test, which for a lot of businesses was easier because no one single factor was determinative. So it can be possible, for example, take real estate agents. So real estate agents, there's really no good argument that real estate agents are not performing work that is in the core of the business. The business exists to sell homes and to help people rather than are purchasing and selling homes. That's what the business is about. And they make a percentage commission on that. So that's exactly the work that real estate agents do. If ABC applied, they would fail the test under B. But because Borrello applies, they don't necessarily fail the test. You have to go back and look at all those other factors. And as far as I'm aware, I haven't seen a case specifically with real estate agents. I mean, you certainly could have a situation where they exert too much control, but as far as I know, they're still classifying as independent contractors, and I'm not aware of a lot of litigation around it because it's just a messier test. Okay, and then there are the specific occupation. So this doesn't have to be a professional services contract. The specific requirements of that labor code don't apply to these. These are specific jobs where there's an exception. Like this professional service contracts, this doesn't mean they're automatically a contractor. What it means is that you go back and look at Borello. So what are these specific occupations? One is a person or organization licensed by the Department of Insurance. So insurance agents. You want to look at the Borello test. Doctors, surgeons, dentists, podiatrists, sorry for the typo there, psychologists, or veterinarians. They can be contractors under the Borello test. Licensed lawyers, architects, engineers, private investigators, or accountants. So you think of kind of white collar professions here with doctors and lawyers and engineers and architects. I was personally relieved to see this included as an exception to AB5 because a longstanding thing in the legal field has been of counsel relationships with other attorneys. So they, and I have an attorney who's of counsel to my firm. So he has his own business. He has his own work location. He provides for all his own overhead. And we work together on cases. And under the ABC test, I probably would have failed because he's doing legal work just like I'm doing legal work. And I guess arguably I could make the same argument against him, but he's of counsel to my firm. I'm not of counsel to his firm. So really it would just go one way. But with this exception, what it means is that then you look at the Borello test. That fact that he's doing legal work, which my firm is doing, is not alone going to be dispositive. You're going to look at, am I controlling the manner and means in which he's performing his work, or am I just looking for results for work product? Okay. And then further down the list, securities, broker dealer, a direct salesperson under section 650 of the Unemployment Insurance Code. So you have to be really careful about this one. I actually have a client who does have workers under the direct salesperson exception. The Unemployment Insurance Code itself has very specific requirements with the contract that you must have with direct sellers. And it's a very unique model. If you have a sales force, it could be something to look into, but it's not without risk. And this particular client I have, they have people that misunderstand it all the time and think that they're misclassifying workers when in fact they're not. What's really unique about it is that these individuals are employees for purposes of the labor code, but they are 1099 contractors for payroll purposes and for the unemployment insurance. And you don't have to pay workers' comp. Again, it's an area you have to be really careful with. So take a look at that. And if you want to have direct sellers in your organization, if you're the type of business that has salespeople, before you do that, make sure you talk to a qualified HR or employment attorney. And commercial fishermen, if you are in that business, you'll be more familiar with that than I am. Newspaper distributors or carriers. And then this again is from for some reason, there was a lot of those cases after Borello dealing with newspaper distributors and carriers, probably less common now as we're moving to more digital. And then international exchange visitor program and competition judges. So, people that work as referees or umpires at baseball games, they're not necessarily employees. Okay, so what should you do? This all seems like a lot. As I mentioned at the beginning, there really is no such thing as misclassifying a worker as an employee. If you treat somebody as an employee, you're going to be safe with this issue. Big caveat. So, you're going to then make sure you comply with all the California Labor Code on a minimum wage and meal breaks, rest breaks, and there's many more. But you're not going to get in trouble for misclassifying. If you get it wrong and you classify somebody as a contractor when they should be an employee, that's when you face the potential risk for all those bad things we talked about at the beginning. So my general advice when I'm advising employers is, when in doubt, avoid it. Don't risk it. It's not worth the risk. This is one area where if I'm on the plaintiff side in a case like this, they're very easy to get wrong, and the liability is just clear. There's no real gray area. It's like if this person was misclassified because one of those things was missed, for example, on the ABC test, there's really no argument that the employer did, shouldn't be held liable. And if I'm advising a business, I say the same thing. If fortunately, I don't have a lot of business clients that have gotten into trouble in that area, but I would give them the same advice. I would say, you need to settle this quick because we're going to lose. So don't risk it. Be safe. Again, I don't mean to overemphasize this. This doesn't mean that legitimate independent contractor arrangements can't exist. They certainly can. I have one. So you can do it. You just really need to make sure that you're looking at it carefully. Don't make yourself easy pickings for the IRS and the plaintiffs firms out there. So briefly and we kind of touched on this earlier, but okay, so let's say you say, okay, Tim, I hear you. I want to avoid the risk. What are but I need to hire somebody, or maybe you have a contractor now. I've talked to a lot of people, some family members even say, hey, I just started a business and I have this person working as a contractor. And I just found out, I really probably shouldn't be doing that. What do I need to do? So it's certainly possible to convert somebody from being a contractor to an employee. If you do that on a very basic level, what are some of the issues that you want to be aware of? As I mentioned before, you want to be familiar with the basics of California wage and hour laws. And there's a lot of information that's available online. There's also book that I use all the time and I recommend to all of my clients. It's put out by the California Chamber, and it's called the California Labor Law Digest. They publish it every year, so it's updated every year. And I have a reference to that on the last note there. So if you are a business with any employees really at all, but especially as you get bigger, you're going to want to have your HR person have a copy of that, and you're going to want to be familiar with the basics. This particular version is really thick. It's about 1,000 pages long, but it's really simple in its format. You can look specific questions up. They have an even more basic one, I believe, on their website that you could take a look at. I like the big long one because I like more detail when I'm looking things up. But some of the wage and hour issues you want to be aware of. You have to pay minimum wage for every single minute worked. Don't round time. Make sure you keep accurate time records. Make sure that your employees, if they're non-exempt, are taking a 30-minute unpaid meal break, at least 30 minutes, no later than the end of the 5th hour of work. Make sure you're giving them at least a 10-minute rest break for every 4 hours or major fraction thereof, which the law says is, I think, 3.5 hours. Make sure you're giving them 10-minute paid rest breaks. Make sure that if you're texting or calling your employees on cell phones, this is something employers get wrong a lot, is because we're all texting all the time. We're calling on the cell phone because most people don't even have house phones anymore. if you're doing that with your employees, you need to pay some portion of their personal cell phone bill if you're not providing a cell phone. So that can, I'm not going to tell you exactly what the amount needs to be. It doesn't have to be their whole cell phone bill, but just it's supposed to be a reasonable percentage based on how much they use it for work. So a lot of businesses don't like that rule. Even bigger businesses are getting this wrong still today. But that is a constant source of litigation. If your employees drive for work purposes, you need to reimburse them at least the IRS rate, which it was around 58 cents. I forget exactly what it is now. I think it might be 60 cents or something. So those are all the some of the big wage and hour issues you want to be aware of. You want to make sure that you're paying them overtime for every minute over 8 hours in a day or over 40 hours in a week. You don't have to double them on top of each other, but you have to make sure you're paying them daily overtime and weekly overtime. And one area where a lot of businesses get into trouble that people seem to be still unfamiliar with is that regular rate needs to be paid, overtime needs to be paid at the regular rate of pay. If you're paying bonuses, other non-discretionary compensation like commissions on top of base pay, you need to factor that in to their overtime rate when you pay overtime. Same is true if you have employees that miss meal or rest breaks. Whenever that happens, the law requires you to pay them 1 hour's worth of pay for the violation. And that's if the meal break is late, if it's short, if they get interrupted and they have to come back to work early, or if they don't take it at all, you have to pay them 1 hour's worth of pay. And a recent change in the law within the last, I think about year or so, maybe it's been within 2 years as time flies, but you need to pay that penalty at the regular rate of pay, not just the base rate of pay. Other issues to be aware of before we get to the questions. FEHA is the California Fair Employment and Housing Act. As I mentioned earlier, if you have more than 5 employees, you want to be aware of that. Another big area, which is also part of FEHA, and there's federal laws on it as well, where we often see employers get into a lot of trouble is not understanding their obligations when employees have medical disabilities, some type of a disability. It's a little bit of a different obligation. If you're aware that one of your workers, one of your employees has a disability, you as an employer have a duty to engage in what's called the interactive process to determine if there's some kind of reasonable accommodation that can be provided that would allow them to perform their work. And you want to document that. You want to make sure you engage in interactive process. What we see far too often is either no interactive process at all or a cursory one where the employer just says, hey, you can't lift this. We can't accommodate you. We have to terminate you. We have to replace you. Especially with smaller businesses, I think it's probably harder because you're so dependent on each worker that if somebody's down and maybe needs some kind of accommodation, it can be difficult to do that. But you want to make sure if you have employees, you're keenly aware of all the rules related to disabilities. Other issues that can get very complicated are leave issues. Especially if you have people that have been with you for longer than a year and working enough hours, they're entitled to certain benefits for different reasons, for medical reasons. It can apply to medical condition of a family member. You want to be familiar with that. And there's so much more. So as I said, you want to look at the California Labor Law Digest. And if you have, more than a handful of employees, and just become really familiar with these issues. So that is it. We have a few minutes left to address some of these questions. And looks like there's 2. So one is regarding single event engagement events, a florist business. Okay, freelancers for the day to set up on wedding day. I would say you want to look at the single engagement event specific labor code. And This is under professional services, right? Or is that under occupations? Let me see, I think it was this one. Maybe it was a different exception. Yeah, it was. So Labor Code 2779. Take a look at 2779. I believe it may be one of the labor code sections that has specific requirements for meeting that. See if it also is one of the labor code sections that says, hey, you need to go back and look at Borello. It doesn't mean automatically they're contractors. What I would be concerned about with setting up, I guess you could have an argument that, hey, they're not really in the business of being a florist like I am. They're setting up. Somebody could argue, well, no, that's part of what you do. You're probably there with them setting up, or maybe have some of your employees. And then, the second part of your question is, even though they have their own business, I would say be really careful about that. It's not a silver bullet. I've had business clients who have hired workers who they really tried to meet AB5 and had the individual get their own business license, have their own workers' compensation, and then still, we got hit with a case because there were some other facts that just, didn't look great. It ended up settling because, even when you're trying to do everything right, I don't want to sound too negative, but it's possible for these cases to come up. So I would take a look at those, talk to somebody who really knows this area of the law, or so if you have an HR organization that you really trust, try that. So then another question is, if an employee's salary, can the company work the employee 24 hours with overtime or mealtime? So just if somebody's salary, no, you can't. You have to pay them for all the hours worked. However, I think maybe what you're asking is if the employee is exempt from overtime. So under the labor code and the wage orders, there are three main, what we call exemptions. So these people are still employees, but they're salaried, but they must also, so on the salary side, they have to make at least 2 times the minimum wage on a salary basis, regardless of how many hours they work. But they also have to meet the exempt duties test. And that's either, the main exemptions are the administrative exemption, the professional exemption, and the executive exemption. And we don't have time to get into all of those. But if an employee is properly classified as exempt, then yes, they can work 24 hours a day without getting paid overtime, and they're not provided with meal or rest breaks. But you have to make sure those exemptions are met. Hiring through Upwork, great question, because I've hired people through Upwork and thought about the same thing. It really depends, I think, on the kind of work that you're having them do. I've hired people to do blog posts for me through Upwork. Other tasks I've done, could that blogger, or kind of falls into one of these categories of content contributor, maybe I would rely on that. I'd have to look at that one closer myself. I don't do that anymore. Ironically, I now have an employee that helps me with my blog posts. Yeah, hypothetically, that person could come say, especially because I have an employee doing it now. If I hired a contractor to do it now, they could say, hey, I should have been an employee. I'm doing what your employees do. It really
Tim?
depends on, yes.
I'm sorry, we need to wind up.
Okay.
We could email answers. I think there are 2 from one person and one in chat, and we have the name of the person.
Okay.
If we have their email address, which we should in the office, I will share the questions with you. And if you would feel comfortable giving a brief answer, that would be helpful.
Okay, great. Yeah. And you can feel free to.
We have
Sure.
2 minutes to wrap up. So if you want to do a real quick on those, you can.
Okay, yeah, let me see. So that was really the upward question. Remote employees out of state. So if they're licensed to practice different, so that one I would need to know more information. I will say, and we can close with this, remote work is becoming a more and more common thing. And there's a lot of issues with it, a lot of issues that are still not resolved. One thing I can say is that if your worker is performing work in California and you are an out-of-state business, it doesn't matter. The California Labor Code is still going to apply to you. Beyond that, all I can say is it's complicated and you need to talk to someone. So I would need to know more about the particulars to answer that question. But feel free to reach out to Jackie. Information here on finding a mentor through SCORE, which I highly encourage. It's a great organization. And thank you all for your time today and your participation. And good luck.
Tim, thank you so much for your presentation. We appreciate it. And we will look at the chat question. I think there's one question we didn't get to, and I've got the name of the person and we'll email them. So
Great.
thank you so much. And I'm going to let you all go.